Hi, whoops, here we go. Hi, everyone, welcome and thank you for joining us tonight. My name is Lisa Kelly and I am the Outreach and Adult Programming Manager for the Long Branch Free Public Library. Welcome. Welcome to our presenter tonight, Michael Coco, RN, Esquire. And I just want to acknowledge our partner for this program tonight is the New Jersey State Bar Foundation. And I just want to take a couple moments before we begin to alert you to some information I put in the chat. If you need to contact me, my email address is here. We are recording the program tonight and we will be posting it to our YouTube channel later on. And you are free to keep your cameras on or off, whatever you're comfortable with. We are going to take questions at the end. We'll have plenty of time at the end, about 7:45-ish, to take some questions before we finish up tonight around 8 o'clock. And if you don't want to forget your question, feel free to type it into the chat, and then we can go back and look for it at the end of Michael's presentation. I would also very much appreciate it if you could put in the chat how you heard about the program tonight, because that helps us with our marketing and our advertising. If you are not already a library patron and signed up for our monthly newsletter, we do put out a great newsletter once a month with all of our upcoming programs and events, and you can sign up for that on our Facebook page or on our website, which is www.longbranchlib.org. So I think that was everything I wanted to say. Also, I do have one more program next week coming up, which is Introduction to Health Disparities in the LGBTQ plus community. And that is presented by Ashley Perper of the Rutgers Cancer Institute Community Outreach Department. That is Tuesday, June 28th at 7 p.m. You can email me and I'll send you the information if you like. My email is in the chat. So tonight's presentation is the history and current state of LGBTQ plus laws, which I'm really interested in learning more about. So without any further time from me, I'm going to turn it over to Michael. Welcome again, Michael. And I look forward to hearing what you're going to share with us tonight. Thank you.
Sure. Thank you, Lisa. I'm going to start the presentation and we can go through it, and I'll take questions at the end. So I'm sharing. All right. So today I'm going to talk about the history and current state of LGBTQ plus laws. I'll shorten that for time. Again, we're doing this through the American Bar Foundation. A little bit of background information on me. I'm a registered nurse and I'm an attorney. I clerked for the New Jersey Supreme Court after graduating law school. And then I worked for health law for a couple of years for a firm. And now I work in risk management and litigation for a hospital system. So the history of LGBT law in the United States goes back to our colonial history, all the way back to 1624 was the first criminal case against a person for the crime of sodomy and a crime against nature. And to be fair, that this was a non-consensual act, but it gives you the background that, you know, these laws were prosecuted even as far back as 1624. And by 1714, before the country was even officially founded, there were sodomy laws in place in the early colonies, and they remained unchallenged until 1925. And these sodomy laws were typically used for prosecution for people who had same-sex relationships. And New Jersey's I have up here is still in effect in some ways. And you can see that the information here and the wording of the law says that, sodomy or infamous crime against nature. And these laws were targeted mainly towards gay people, but there's an interesting case in New Jersey Supreme Court in 1973. This was State versus Lair. And the defense in that case, this was a case where a straight man had been accused of sexual assault and sodomy, and his defense was, hey, this is a law meant against gay people. Why are you prosecuting me for it? And the New Jersey Supreme Court said, no, it's really a law against both, unless you're married. And this is an interesting cravat, because in 1973, there was a Supreme Court case that had already been decided in 67 that we'll talk about. And that case basically said that states can't prohibit certain activity for married couples. It was came out of Loving versus Virginia. So in this way, it was a case against a straight person, but it ended up, marriage being a defense. And of course, same-sex couples could not get married at that time. So really just kind of further went against the idea that this was what's called a facially equal law, and that really this was a law to punish, same-sex relationships. And these laws were upheld by the Supreme Court in 1986 in a case called Bowers versus Hardwick that we'll come back to. A quick note on what's called federalism in the legal sphere. And federalism is the idea that the federal government has specific enumerated powers that it can a sphere that it can work in, and then states have the power to govern all of the other aspects like morality. They have general police power. They pass these anti-sodomy laws. They pass same-sex marriage bans. So this is all kind of the domain of the state. And the federal government itself got into the laws against homosexuality in the 1950s. There was a report titled Employment of Homosexuals and Other Sexual Perverts in Government, and it was distributed to members of Congress, and it basically said that these people were a security risk, which is something that the government says generally about people that they don't like, and they still do it, and they were doing it back then. And then in 1953, there was an executive order by President Dwight Eisenhower that banned gay people from working in the federal government as a security risk. And that included the military, which really was in place until 1993, when Bill Clinton signed Don't Ask, Don't Tell into law, which we'll talk about. There was some progress in the 1960s. So the 1960s is this big civil rights movement era, mainly known for civil rights for African Americans, but also had a lot of progress with the LGBT community. In 1962, Illinois was the first state to decriminalize same-sex acts between private adults. And in 1967, the United States Supreme Court decided a case called Loving versus Virginia. Now that case overturned a ban on interracial marriage, but it's a really important case because other cases that are important to the LGBT community arose out of that case and were based in part on Loving. And then in 1969, we have the Stonewall riots. They were June 27th to 29th. And those happened in New York City, and Greenwich Village had a large gay population. The riots happened because the police had been harassing the community there. And then on this Saturday morning, they had raided a lot of the gay bars, and Stonewall was one of them. And the residents there and the regulars who were in that area really pushed back at this point and rioted against the police. And it was a pivotal defining movement in gay rights because it really started a pushback from the gay community. And then we fast forward a little bit to the 1990s when a lot of stuff starts to happen in terms of gay rights. And in 96, I want to just draw your attention to this case, Romer versus Evans, because I think it's a little bit unique in that, you have a conservative Supreme Court at that time. And what was happening was you had municipalities that were extending protections to gay people. They, for example, the city of Denver passed laws that said you can't discriminate against gay people in housing, you can't discriminate against them in employment. And Colorado, which was much more politically purple than it is today, that passed a law that said our municipalities can't grant protections to gay people. And the Supreme Court said that that violated the Equal Protection Clause. And it was really the first case that the Supreme Court really upheld rights for the LGBT community specifically. So it's kind of important there. And the real, I call it a problem case. It was a good case for LGBT people in Hawaii, but we go down here to the Hawaiian Supreme Court and Bear versus Miki. And in 1993, that Supreme Court held that it was illegal for the state to discriminate against same-sex couples in marriage because of the rights that were afforded to them by marriage. And this was a real problem for social conservatives. And it started a real large pushback. And what you get from that is what's called the Defense of Marriage Act. Now, one of the reasons that this was such a problem is the United States Constitution has a provision called the Full Faith and Credit Act. And the Full Faith and Credit Act says that one state has to honor another state's judgment. And because marriage is a civil judgment, other states would have had to honor Hawaii's same-sex marriages. That's why you can be married in New Jersey and go to Pennsylvania and you don't have to get remarried. The state has to, by constitutional command, has to honor that. So, this was a real problem for social conservatives. So they got together and they passed this law called the Defense of Marriage Act. It had nice bipartisan support from Democrats and Republicans, which usually means that it's bad for you, but that's what happened. And it had the major points of defining marriage between a man and a woman. And it said that states don't have to recognize other states' marriages, which was really blatantly unconstitutional based on the full faith and credit clause. But that's what they did. And it was seen as a compromise. So it was actually upheld by federal courts in the beginning, and it was eventually overturned in U.S. versus Windsor in 2013. But until that time, the federal courts had upheld it really because it was seen as a compromise. And then also in the 90s, President Clinton passed the Don't Ask, Don't Tell law, which was, again, supposed to be a compromise. It was initially seen as progress for the LGBT community, and it was in effect from 93 to 2011. But what happened was, the military became very aggressive in discharging people under this policy because it kind of gave them a reason. They said, oh, well, you violate Don't Ask, Don't Tell, we can kick you out. And what they did is they would investigate people. They would go to bars and clubs where in the 90s you had barcodes on your licenses like you do today, but they would scan them and they would actually go in and they would get these lists from people and investigate them. So there was a lot of pushback to it. Thousands of service members were discharged under Don't Ask, Don't Tell from 94 to 2008. And it was really a disservice, I think, because that was around the time when we had a lot of problems with, of course, Al Qaeda and domestic terrorism. And a lot of these service members were service members who had come from those countries because they were oppressed for being gay, and then they were very useful in their skills in terms of they were a lot of translators and things like that, and then they were kicked out of the military because of this policy. So it was a real problem, but it's been since overturned. And then in the early 2000s, we sort of have this culture war still going on. Former Vice President Al Gore was supporting definition of marriage between a man and a woman. And then George Bush wanted a constitutional amendment to ban same-sex marriage. So we have both parties really not very supportive of same-sex marriage at that time. Now, the social conservatives knew that DOMA was unconstitutional. That's why they wanted to make an amendment to ban same-sex marriage. And you still had a lot of progress in the states. So in Massachusetts, the Supreme Court came to the same conclusion that Hawaii did and said that you had to give same-sex couples rights. And Mitt Romney did what Hawaii did to get around that ruling, is that they created a domestic partnership to try to get around that ruling. And then in 2008 in California, there was a huge battle for, if you might remember, depending on how old you are, Proposition 8, which would ban same-sex marriage in progressive California. And even John McCain at the time was running for president. He was there to campaign. So it became a national battleground for same-sex marriage. And it eventually passed. The ban eventually passed. So even in California in 2008, it was still banned. And there were legal fights after that, but it just goes to show you the state of progression that was there at the time. And between 1998 and 2012, 30 states had passed laws defining marriage as between a man and a woman, which is 8 states short of the constitutional amendment that George Bush wanted. So, there was a lot of pushback even in the early 2000s. And we also did see a lot of progress, though. Lawrence versus Texas was a Supreme Court decision. It was 6-3. Justice Kennedy was on the court at the time, who's a libertarian, conservative. He typically ruled with the more liberal part of the court on these issues, and it overturned a Kansas law criminalizing gay and lesbian sex for being unconstitutional. So it actually overturned this Bowers decision in 86 that upheld sodomy. Now it was reversed. So it struck down basically all of the sodomy laws in the United States as they were applied to gay people. In September of 2011, President Obama lifted the ban on LGBT plus service people, kind of overturning Don't Ask, Don't Tell. That was one of his campaign promises. So now we had people serving openly in the military, which was a huge win for LGBT people, because there were a lot serving and they wanted to be able to serve openly. And then in 2013, the U.S. Supreme Court, in a 5-4 decision, finally overturned DOMA. That was, again, the act that said states didn't have to recognize other states' marriages. They overturned it on the Equal Protection Clause, and it was a big win, and it was kind of the precursor to the same-sex marriage case. And in 2015 is really the big case here, Obergefell versus Hodges, and 5-4 with a conservative 4 justices dissenting, and again, Justice Kennedy, the libertarian on the court at the time, joining with the left wing of the court in holding that the Due Process Clause and the Equal Protection Clause guarantee same-sex couples the same rights as heterosex couples. And when they ruled that, they ruled on something called they ruled on the due process clause, but they ruled on something called substantive due process, and that's important for the future. So I'm going to talk about that a little bit later, but just keep that in mind as we go through. And in 2017, we get some more pushback as President Trump was the president, and he started reversing the ban on transgender, specifically persons in the military. So there was a little bit of a pushback there. But in 2020, again, the Supreme Court we see favoring the LGBT community. And it's important to note that in 2020, this is a very conservative court, but they held in Bostock versus Clayton County, Georgia, that Title VII, which is the title under the Civil Rights Act that, people sue, you discriminated me based on race and things like that. So this is the act that people use for cases for discrimination in housing and employment and all of those things. And they ruled that it does include LGBT people. And for, kind of a law nerd like me, kind of surprised, because that was an interesting decision, legally speaking. So I was surprised at that ruling. But now you have protection for LGBT plus community for employment in every state, regardless of what the state law is. So that, again, was another huge victory for the LGBT community. So under our current laws, you have federal protection, again, the one I was talking about in the Civil Rights Act. So you have employment covered with that. You have housing covered with that. You have coverage for a lot of places that are open to the general public. And you also have protection against discrimination in schools under Title IX. And I put likely there. I didn't find any cases on it, but based on the climate, the political climate, and the administrative climate there, you're going to have protections on that. For more practical considerations, you should, if you feel like you're being discriminated against, you should make your concerns known. Employers actually need to have notice that a person is a member of the LGBT community in order for them to have protection. So, for example, if you were working somewhere and you never had a discussion with your boss about, you being gay or transgender or something like that, and you're eventually terminated, they can use as a defense, hey, we didn't know this person was gay, so we couldn't have discriminated against them for it. Now, you don't have to, come out to everybody, but there are things called constructive notice. So, even if you didn't say anything, maybe you had a picture of your partner on your desk or something like that. So there are ways to show constructive notice, but just keep that in mind, that notice is a requirement for that type of thing. And make your concerns known. Write down things. If you feel like you're being discriminated against, you should write things down as they happen so that they're fresh in your mind. Gather evidence, and just, kind of keep that in your pocket in case something happens. And if you are being discriminated against, you'll have that. And don't wait too long if you feel like your rights are being violated, because you have a relatively short time to pursue a claim for discrimination, especially in employment. And it's 180 days under the federal rule, or 360 under a lot of state rules like New Jersey, which are a little bit more lenient, but it's still not a whole lot of time. So set deadlines and seek assistance if you fear you are being discriminated against, whether it be in employment or whether it be in housing. I think it was on the other slide, but there are rules for housing discrimination. Situations not covered is discrimination by private groups. So, for example, the Boy Scouts of America can discriminate their private group. Hate speech is not covered. You might have some leniency in schools and things like that for bullying laws, but generally it's not covered under hate speech, so people can say what they want. Religious ceremonies are not covered. You can't force the Catholic Church, for example, to give you communion if they are against it, if they are against same-sex marriage or LGBT community. Blood donation, for some reason, is still an issue in certain areas, that depending on the blood donation organization. And then adoption cases. And this one is really interesting because I have on here a case that is Fulton versus City of Philadelphia, which was decided in 2020, the same year as they extended rights to same-sex people under the Civil Rights Act. And again, the same court said that if you are a religious institution, you can discriminate against LGBT families for adoption. And what happened was there was an adoption agency that was Catholic, and they did not adopt out to same-sex couples. And the city of Philadelphia said that they weren't going to include them in their adoption services. And they sued the city of Philadelphia, and the Supreme Court said that the city of Philadelphia had to include them in their adoption agencies. So I think that we're going to see a trend here where you have LGBT rights coming up against religious rights. You're going to see this particular Supreme Court that we have right now favoring religious rights. However, if you see LGBT rights generally coming up, they might be more inclined to extend rights to them, for example, under the Civil Rights Act. So here are some issues that are undecided and some future questions that are coming up. One is this right to religious expression and artistic expression. And you might have heard of these so-called baker and floral cases. And that's where a company, usually a sole proprietor, a bake shop, for example, will be asked to make a cake for a same-sex wedding, and the person refuses. Now, under certain state laws and federal law, you would have to you couldn't discriminate against people based on their sexual orientation. So what happens is those cases go into the courts, and the court has to balance the religious affiliation of the person against the civil rights statute. You're also going to see that, I think, with companies covering surgery and hormones for transgender employees, which you see for contraceptives a little bit right now. And again, it's going to come down to that religious versus individual rights question. There are some questions on education out there right now. When is it appropriate to teach LGBT topics? Students using different restrooms, and of course, Florida's parental rights law, the so-called Don't Say Gay law. And is parental disclosure required or prohibited if a teacher or school knows that a student is gay or transgender? And these are all going to be future battles. The big one, I think, is going to be topics in schools. And in New Jersey, the New Jersey Department of Education just came up with new guidelines that lowered the age group of these type of topics, and it has upset some people, and there's some pushback there. So I think you're going to see laws like Florida's parental rights laws being introduced in a lot of states, and there's going to be battle there versus what is the schools and the teachers' free speech rights to teach about these topics versus the religious rights of certain students, or even the parental rights. There are a couple cases out there that are already being brought up about parental constitutional rights for people to bring up their children in a certain way. So these are going to be really interesting topics as we move along. And now I want to talk a little bit about Dobbs, uh, the Dobbs case, which is the Supreme Court case that is all the talk right now. Dobbs versus, I think it's Jackson Clinic of Missouri. And it is the case that was leaked by the Supreme Court. It deals with abortion, but the really interesting thing about it, and I say this with the cravat, that it hasn't been officially published yet, although Justice Roberts said that it was authentic. It might change the original publication, but this is going off of where the court is headed, I think, and it really gives a lot of insight on the five justice conservative part of the court, that how they're going to be viewing other future questions. And I assume that case will either be decided tomorrow, either be published tomorrow morning, or if not, then probably on the 29th. And that case was authored by Justice Alito. And the big issue there that is relevant to our discussion on LGBT rights is that substantive due process, which I was talking about in Obergefell, why that was decided, because substantive due process is kind of this idea that we have constitutional rights like the right to privacy and the right to marriage that are not enumerated in the Constitution. That's called the substantive due process right. It's under the 14th Amendment. And the conservative majority of this particular court that we have now does not like the idea of substantive due process. They don't think that we should have it at all. In my opinion, that's the way that I read these cases. And there are a lot of doctrines that this will impact. It impacts privacy, it impacts Miranda, it impacts contraception, interracial marriage, same-sex marriage. All of these things that are not specifically in the Constitution are kind of undermined by this particular decision, and not the decision itself. Really, abortion really isn't the topic, but it's the reasoning that's important. And the reasoning is that that this idea that we have these substantive due process rights that are not enumerated, that the Supreme Court has endorsed, puts a lot of stuff into question, and whether or not these cases are going to be upheld into the future, and whether we're going to continue to see things like same-sex marriage and LGBT rights be afforded their own special protections. So again, just talking a little bit more about the leaked draft that expressly overturned Roe versus Wade. And so that's another thing that is interesting, and that the court didn't really have any qualms, which surprised me. It didn't really have any problem with saying, we think that this prior case was wrong, and we're just going to overturn it. I thought that they would do it gradually if they were going to do it, but it was kind of a shock to me. So it really puts other cases in perspective of whether or not they're going to stick around. Again, Alito attacked the idea of substantive due process, and their view is that if it's not in the Constitution, it's not free speech, it's not the right to bear arms, it's not the right to peaceably assemble, then you don't have it. And the only time you get one of these substantive due process rights is if it is deeply rooted in the nation's history and traditions and English common law. And he cited a case from 1300 England. So when he says deeply rooted, he's not messing around. So it's a very, again, if it is published in the way that it was leaked, it is a very narrow view of rights in general. So I think it's definitely going to have an impact on future LGBT cases and rights. And I said that it lays the foundation for overturning Obergefell. I don't think that that's going to happen. I personally don't think that that's going to happen. I hope that it doesn't happen. But I mean, it's not a crazy idea if you read the actual case in Dobbs and you look at how Obergefell was decided a lot on this due process and liberty rights, then it's definitely a possibility. So that's kind of where we are. I have my old law firm email address up here if anyone has any questions later on. You can email me at that. I do check it. But for now, I can take questions from anyone who has them. Let me stop my share. And okay, so question, are private groups also nonprofit? Are nonprofit groups always public groups? So you can have a private group that is either for profit or well, more so companies are for profit and nonprofit. That's more of a corporate designation. When you have a private group, they can form a nonprofit company. So, for example, the Boy Scouts of America are a private group, but they also form a corporation, a company. I don't know if it's an LLC or corporation, but they can form a company to collect money and do business and things like that in the company's name. And that company can apply for nonprofit status. And if it applies for nonprofit status, it gets certain protections and it gets certain state tax benefits. And if there are state tax benefits, it can also apply for federal tax benefits. And if it does that, it does have to be non-political to get that federal tax benefit. But to be non-political doesn't necessarily mean that it can't have certain views. It just can't lobby. So that there are a lot of rules for nonprofits and in terms of what is lobbying and what's not lobbying and what they can do. But you can still have a not-for-profit group that has certain religious views, but they'll usually go under a religious group. But yeah, that kind of depends on what the group is doing and whether or not it's going to form a company for its finances and things like that.
Yeah, I thought that. I was just curious because I'm wondering how many other groups like the Boy Scouts. I mean, I was aware of the Boy Scouts and what their views are, but how many other groups, that could do that if they were what we would think of as a nonprofit or.
Yeah, and I mean there are rules, and it depends on states have rules for nonprofits, and you could get a state rule that says if you're a nonprofit, you can't discriminate, and it usually comes down to a factual question of whether or not the nonprofit can exclude certain members. Generally, it would be very hard without losing their status. But again, if they did it under their religious rights, they could probably do it in that way. But in terms of just generally excluding it, I think that it would be difficult for them to do that and maintain their nonprofit status.
Thank you.
Sure.
It looks like we have another question also.
In terms of gay rights, can you list the rights or protections that we could lose through the Supreme Court? So I think that the biggest one is going to be the the marriage case, because that case was based on this idea of substantive due process, and or at least in part. The full faith and credit clause might save it, but substantive due process is going to take a hit with that case. And also, interestingly enough, one of the first cases that was decided on this issue is the anti-sodomy laws, which were decided on this idea of privacy and this idea of substantive due process. So that those laws in particular, or that case in particular, could get reversed because they could say, well, we're not going to interpret privacy and we're going to let states do what they want, which goes back to federalism, which this particular court favors, I think, federalism, which isn't necessarily a bad thing depending on how far it's going to go with it, but it favors the idea of states making their own rules. And it could come back and say, if states want to make anti-sodomy rules, they can do that. If states want to define marriage as one thing or another, they can do that. If states want to prohibit abortion, they can do that. So a lot of those type of laws could be in question. And I don't think that they will go back on the civil rights law, because that was actually a pretty recent case, and it was a federal issue. And again, that they're saying that from a federal standpoint, that you're protected, but once you start getting into this area of morality and religion and states' rights, I think that this particular court is going to be deferential towards states in that area.
So, Michael, you think it's unlikely then that there'll be rollbacks on the housing and employment type protections?
I don't think that there will be, because the case that extended those rights was as recent as 2020, and it was an issue of federal law that the Supreme Court was extending. So they seemed fine doing it. It didn't really, for them, wasn't really pitted up against any type of specific religious issue or any states' rights issue. So the Supreme Court seemed okay with doing that. And I would be surprised if they rolled that back. I was surprised that they did it in the first place. So I'd be surprised if they rolled it back. I don't think that they will.
What about the military?
The military, well, I don't think from a Supreme Court type of perspective, the Supreme Court doesn't like to get involved with those type of issues in the military at all. They're very hands off. Now,
Okay.
what will happen is whatever type of administration you have might roll that back. So you saw that happen under President Obama. He was more of a progressive guy, and he ended Don't Ask, Don't Tell. He allowed people to serve openly. And then when Trump came, he was more conservative, and he tried to roll that back a little bit. And now when we have Biden, he put the brakes on Trump's idea to roll that back. So that's really going to be an executive decision in terms of who the president is and who their administration is and what their political ideology is of that particular administration.
Okay.
And they're going to be the ones that are going to be appointing the generals, and the ideology of the generals is going to be important too. I think that it would be difficult even for a conservative president to roll that back at this point, now that it's kind of it's been
It's sort of baked in now, right?
yeah, it's sort of the rule now, and everything didn't fall apart when they did that in the military, and it kind of hurts any counter arguments to it. So I don't think that a president, a future conservative president, would have a whole lot of success in rolling that back.
Okay,
My personal opinion.
well, they're gonna focus on the schools and,
Yeah,
don't say gay and,
that's gonna be an issue. That's gonna be a battle. It's gonna be I think it's probably gonna be one of the bigger battles that's we're looking at in terms of these issues. And it's going to come down to the free speech, I think, of the schools versus parental rights. And there might be some political involvement too in terms of passing additional legislation and people getting involved in local school boards and having local school boards decide. So it's a new issue. And also what I see just recently too is the transgender people in athletics and how they're going to balance that, because that's going to be a big issue in terms of whether or not you have advantages there that are unfair versus letting people participate. So
Yes, I was just going to bring that up. I think that's going to be a very interesting battleground to watch how that progresses.
yeah, and I think that what will happen is the women's sports in particular, I think that they'll tighten up some of their requirements in terms of people being on hormones and when they started transitioning versus being able to go to the women's and men's sports, or perhaps have an open league, which I think is what swimming is doing now, where you have co-ed participation. So it'll be interesting to see how all of that pans out as well.
Yes. Do we have any other questions for Michael? No? Well, thank you so much, Michael. That was very interesting.
Sure. Thank you, everyone, for coming. And again, if you guys have any other questions, you can always email me.
thanks a lot.
And thank you. And feel free to let people know if they missed it tonight that the recording will be on YouTube.
Yep.
And they can watch it later. So thank you again, Michael, for allowing us to record the program.
Sure.
And thank you to those who joined us this evening. I hope you have a very nice rest of your night and a wonderful summer, and that you'll join us for more events in the future. So
Thank
have
you,
a good
everyone.
night.
Good night.
Thank you. Good night.